Hi everybody, Bill Prince here. Welcome to Legal Environment of Business. What I plan to do is have approximately a 5 to 10 minute PowerPoint lecture presentation for each of the chapters that we will be covering this semester. Chapter 1 of our text deals with the law. Since we are dealing with the legal environment of business, it is important to understand the laws that will come into play during our discussions throughout the course. Why does society have laws? Well, there are several reasons for that. First, the main purpose of laws and the main purpose of government is to provide order within our society. Without order in our society, we would live in an anarchy. Without order in our society, without laws in our society, it would be extremely difficult to conduct our daily personal and business activities. We want to have a legal system that is flexible yet predictable. In other words, we want to be able to get up in the morning and know what behavior of ours is acceptable and what behavior of ours is not acceptable. On the other hand, we want to have a legal system that changes with the times. The world that we live in 2017 is significantly different than the world our founding fathers lived in 1787, and as we will see, the law has developed over the course of those years to fit those lifestyles. One of the primary purposes of our legal system is to create and have enforceable rules governing relationships amongst individuals and society. And the bulk of our course in Legal Environment of Business is going to be to explore how those rules that are created by our society impact the businesses that operate within that society. In the United States, there are several sources of laws. These are the places where the laws and the rules come from. The highest law of the land is the United States Constitution. It is the supreme law of the land. Article 6 of the U.S. Constitution says that it is the supreme law of the land, and all actions and other laws must be consistent with the United States Constitution to be considered constitutional. The Constitution is an extremely resilient and enduring document. From the date that it was originally signed in 1787, it has only been amended 27 times. The Constitution is a remarkable 11 or 12-page document, and I would encourage you all to read it if you've never had the opportunity to do so. The second type of or source of law in the United States is statutes. Statutes are laws that are passed generally by elected assemblies. Congress, the Senate and the House of Representatives in Washington, D.C., is such an elected body. The State House in Jefferson City, Missouri, is such an elected body. Springfield City Council, Greene County Commission, these are all elected bodies that pass statutes, laws, and ordinances. The third source of laws in the United States comes from regulations. As we will see, these can have significant impact on the business environment. We are coming into a new presidential administration, which, unlike its predecessor, tends to be very anti-regulation, very regulation adverse, and we will see over the course of the next several years how that develops. Lastly, the last source of law in our country is what's known as common law or case law. These are the decisions and laws made by judges. Judges hear cases, judges write down their decisions, and under the laws of our system, future judges are required essentially to follow the laws of the prior judges. These two concepts are known as precedent and stare decisis. Precedent is a previous decision made by the court. For example, in the early 1970s, a case that everybody has probably heard of, Roe versus Wade, was heard by the United States Supreme Court and decided. In that case, it was declared essentially that abortion was legal in the United States of America. Thereafter, any case that would deal with these sorts of same reproductive rights issues would have to decide consistently with the decision in Roe versus Wade. Roe versus Wade is the precedent. The concept of stare decisis is the idea that courts are generally required to make the same decisions as earlier courts when faced with the same issues and facts. Generally speaking, courts should not overturn its own precedent unless there is compelling reason to do so. Exhibit 1-1, which also appears in your text, shows you the various aspects and areas of the law that impact the business entity. We will spend time talking about most, if not all, of these different areas. Within the general body of the law in the United States, there are several classifications. There is what's known as substantive law, and there is what's known as procedural law. Substantive law is the law that creates rights and obligations between parties, individuals, and the state. This is what we think of when we think of contract law, criminal law, property law, personal injury law, that type of thing. Procedural law, on the other hand, are laws and rules that outline how the substantive laws and rules are to be carried out. Procedural rules do not have within them substantive issues. Procedural rules will do things such as tell a party who has been sued how many days they have to respond to that lawsuit. Procedural rules will talk about basically the rules of the game for how the lawsuit is to be conducted. We also have what's known as civil law versus criminal law. Civil law typically deals with private disputes between individuals or corporations and individuals, and in most cases, the entities involved in civil law cases are private people, not the state. Generally speaking, sanctions for civil law are monetary damages, and we think of these kinds of cases involving contracts, negligence, medical and legal malpractice, that type of thing. Civil law, the other side of the coin, is criminal law. In criminal law, the wronged party is the state or the government. And in criminal law, states may in fact deprive, with due process of law, people of their life, liberty, or property. We think of this as cases where individuals have murdered somebody, where individuals have committed fraud, where individuals have raped, robbed, pillaged, that type of thing. That is a very brief introduction of the general nature of law. Hopefully that will provide a good discussion and good starting point for you as you read the chapter and answer the questions dealing with Chapter 1. We will talk to you again in Chapter 2.